Hancock, Daniel, Johnson, and Nagel. We are pleased to present to you today on the Virginia Healthcare Decisions Act. This presentation is in honor of National Healthcare Decisions Day, which falls each year on April 16th and aims to help people across the United States understand the value of advanced healthcare planning. As a quick disclaimer, we are obligated to inform you that this presentation is not intended to be legal advice. HDJN is offering this presentation as an educational opportunity to learn more about Virginia's laws and advance directives. You should contact legal counsel if you have questions when applying the law to individual facts and circumstances.
Now, let's jump right into what we're here to discuss. The goal of today's presentation is to provide you with a basic understanding of Virginia law on advance directives, so that you as a healthcare provider can feel comfortable having these very important and necessary conversations with your patients and their families. Conversations about advanced care planning are much more prevalent today than they were a decade ago, particularly for the elderly population or those suffering with a terminal illness. Recent studies indicate that nearly 70% of older Americans complete an advance directive prior to their death. And this is significantly higher than the rates reported a decade ago, which were in the 20 to 30% range. And the great news today is this trend is likely to continue, particularly given last year's monumental change in the advanced care planning landscape. Effective January 1st of 2016, Medicare began reimbursing physicians for having advanced care planning discussions with patients and their families. Now that physicians will be reimbursed for their time, the hope is that this will encourage more physicians to have these important conversations, allowing patients a better opportunity to have their treatment preferences known and honored. Patient education regarding disease trajectory, prognosis, and the importance of advance directives is crucial to improving the end-of-life care and outcomes, and the conversations we should have before patients become too ill to communicate their wishes. While studies indicate that the utilization of advance directives has increased significantly in the elderly population, it's important to note at the outset that advance directives are useful for people of all ages and any health status. That's right, any of us, in fact, can be struck by an unfortunate accident or illness at any time in our lives. So, why ask your patients to create an advance directive? Or better yet, why should each and every one of us, that's all of us, create an advance directive? Well, the benefits of advance directives are real. Studies have shown that conversations regarding advanced care planning and advance directives offer many positive outcomes. For instance, can conversations regarding advanced care planning increase compliance with patients' wishes and improve quality of life because they make patients' treatment preferences known up front? And they also allow patients to designate the person they feel is the right person to make their healthcare decisions, rather than relying on strict next of kin standards and surrogate decision maker laws that are broad and strictly defined to be applied to the entire population. Advanced directives also ensure that patients' healthcare choices are honored by their family and their treatment teams. I can't tell you how many times we're asked whether a family member can make treatment decisions that are contrary to what the patient told their treatment team they wanted. But because the patient never put it in an advance directive, issues arise. In addition, an advance directive reduces the burden on families. Studies have shown that advanced care planning lowers risk of stress, anxiety, and depression in surviving relatives of deceased persons. And finally, advance directives also have the potential to reduce family conflict. Sadly, these situations bring out the worst in people, and there's a clear advantage to having advance directives because they decrease the opportunities for families to fight over the care of their loved ones and instead can focus on the moment. For you as a provider, an advance directive also offers the following benefits. It allows you to provide better care to your patients, because having a discussion about advanced care planning opens up the conversation with patients and provides an opportunity for you to provide more education regarding the diagnosis and treatment options. It also provides a platform for you to set appropriate expectations and limits on treatment, which improves patient satisfaction and reduces liability. Advance directives also reduce liability for the treatmentee. As a provider, you don't have to worry as much about the legal liability when you have documentation from a patient demonstrating that they do not want life-sustaining treatment, for instance. For those patients who do not want aggressive treatment, it can help improve quality and efficiency of care and lower the end-of-life healthcare costs. But on the other hand, if a patient who does want the most aggressive treatments available, provided they are medically appropriate, then it allows the patient to say so and to have their wishes honored. Emerging data has shown that advanced care planning does reduce end-of-life care costs without increasing mortality. And that's an important statistic. I want to provide a bit of history on the evolution of advance directives in Virginia. As most of you know, the Virginia Healthcare Decisions Act is the law in Virginia that governs advance directives and substitute healthcare decision-making in the absence of an advance directive. The law was enacted in response to the ongoing ethical debate nationwide over end-of-life decisions and the withdrawal of life-sustaining treatment from those in a vegetative state or suffering from a terminal condition. In the 1980s and the 1990s, cases like Terri Schiavo and Virginia's own Hugh Finn case highlighted the importance of having an advance directive early in life. As many witnessed through state and national media coverage for over 10 years, both of these patients suffered in a vegetative state while ongoing court battles took place between family members and trying to decide whether life-sustaining treatment should be withdrawn. In both of these cases, neither individual had an advance directive. In 1990, Congress passed the Patient Self-Determination Act, which incentivized hospitals, nursing homes, and hospices to implement programs that provide patients with information about their rights under state law regarding healthcare decision-making and advance directives at the time of admission. This act also prohibits institutions from discriminating against patients who refuse to create an advance directive. In 2009 to 2010, substantial comprehensive revisions were made to the Virginia Healthcare Decisions Act. Originally, the law only allowed an advance directive to designate a healthcare agent and specify whether a patient did or did not want life-prolonging treatment, should they be diagnosed with a terminal condition and unable to communicate their wishes. Following major changes in the law in 2009, advance directives today not only address end-of-life treatment for those in a terminal condition, but also allow patients to dictate any and all forms of healthcare treatment they do or do not want at any stage of life. Today, an advance directive can specify any and all types of healthcare treatment, including providing instructions regarding medications, surgery, blood transfusions, chemotherapy, radiation therapy, psychiatric treatment, life-prolonging procedures, palliative care, and even admission to a particular nursing home, assisted living facility, or other healthcare facility. Before relying on an advance directive, or an agent appointed under an advance directive, the law makes clear that the patient must be determined to be incapable of making their own healthcare decisions. And for those suffering with long-term mental incapacity, the determination must be reassessed every 180 days. Today, the Virginia Healthcare Decisions Act also specifies how to handle situations where the patient objects to treatment and allows a patient to designate an anatomical gift in the event of death, and also allows a patient to authorize participation in healthcare research. In 2015, our Virginia legislature again reacted to an event that inspired an ethical debate around the country. In 2013, a pregnant woman in Texas suffered an embolism and was declared brain dead. Sadly, she was pregnant, and a legal dispute arose as to whether she was legally dead and thus not in need of life-sustaining treatment. Texas law at the time complicated matters because it prohibited the withdrawal of life-sustaining treatment for pregnant women. In January of 2014, ultimately, the Texas court held that the woman was in fact legally dead and life-sustaining treatment was withdrawn. Virginia law did not have a prohibition similar to the one in Texas, but to provide clarity, Virginia passed legislation in 2015 which allows a woman to specify whether or not she would want life-sustaining treatment administered or withdrawn in the event she is pregnant, suffering from a terminal condition. This directive may be different from what she would want if she is not pregnant. Virginia's Advance Directive Law was again updated last year in 2016. Effective July 1st of 2016, all patients discharged following involuntary mental health care treatment must be provided with information on how to complete an advance directive and must be provided with a copy of the advance directive form if they've not already executed one. Additional revisions were made in 2017 to revise the technical requirements of the Healthcare Decisions Act. First, HB 1548 and SB 1511 expanded the list of providers who may make a capacity determination where the proposed healthcare decision is the admission to a mental health care treatment facility. If the patient has executed a valid advance directive authorizing an agent to consent to such an admission, then the law now permits a lack of capacity determination to be made by the attending physician, a psychiatrist, or licensed clinical psychologist, a licensed psychiatric nurse practitioner, a licensed clinical social worker, or a designee of the local community services board. Also, these bills expanded the list of providers who may attest in writing that the patient had capacity at the time the advance directive was executed. And this is required when seeking to treat over patient protest, but we're going to address that at greater length later in the presentation. One other bill I want to mention for this year's legislative update was HB 1567, which requires entities who process Medicaid eligibility applications to disseminate advance directive information to individuals who are applying for medical assistance. And this includes information about the purpose and benefits of advance directives and how the applicant can make an advance directive. Now, without further ado, I want to provide some general background information on advance directives. And this may be reviewed for many of you, but to summarize, advance directives created in Virginia must be made by an adult capable of making an informed decision. They will not become operational until the patient has been formally determined to be incapable of making an informed decision, which we'll address further momentarily. They also may provide specific instructions regarding treatment, and that would be known as also as a living will. They may appoint an agent to make healthcare decisions. It's also sometimes referred to a healthcare power of attorney. Advance directives may also specify an anatomical gift and may authorize participation in healthcare research. And so what are the requirements for creating a valid advance directive? Well, it's simply that the advance directive must be signed by the declarant in the presence of two witnesses who also sign the document. The patient must be competent to make their own healthcare decisions, and the witnesses must be 18 years of age or older. In Virginia, the witnesses may be a spouse, blood relative, or employee of the treating healthcare provider, which is not the case in all states. But that being said, to avoid the appearance of conflict, it is generally a best practice for the agent not to be one of the witnesses, if that's a possibility. Also, unlike some states, a notary is not required in Virginia, and healthcare providers may rely on a copy of advance directives. And while it's best to have a written advance directive, it is possible to create one by oral direction to a healthcare provider in limited circumstances. In order for an oral advance directive to be valid, the patient must be suffering with a diagnosed terminal condition, and the patient's wishes regarding treatment must have been stated in the presence of the attending physician and two witnesses. And while not legally required, we always recommend that the attending physician fully document the conversation with the patient and the patient's wishes in the medical record. Also, both witnesses should attest to the oral advance directive by signing the documentation. And for purposes of creating an advance oral directive, the term terminal condition is defined as a condition caused by injury, disease, or illness from which, to a reasonable degree of medical probability, a patient cannot recover, and the patient's death is imminent or the patient is in a persistent vegetative state. Interestingly, there's no legal requirement that the advance directive be dated, but we do recommend it as a best practice so that if more than one advance directives have been executed, and there is in fact a conflict, those who need to rely on the document will know which is the most current and applicable advance directive. Virginia has adopted template language for an advance directive, and although use of the template statutory language is not required, it is simply a suggested form with language provided to ensure that the patient has considered the full scope of their right to make healthcare decisions and that all the Virginia statutory requirements are met. Forms that contain the statutory language have been published by the Virginia Hospital and Healthcare Association and are available on the Virginia State Bar website. When assisting patients with the creation of an advance directive, it is important that the patient understand that they can appoint a specific individual to make healthcare decisions for them in the event they are able to make their own decisions. If you have a patient that wants to keep it very simple and all they want to do is appoint a specific person to make decisions for them, they can do just that. Ideally, they would have that conversation with the person, the proposed agent, and would discuss their beliefs, their preferences, and also even their religious preferences with the proposed healthcare agent. And when choosing a decision maker, patients should choose someone 18 years of age or older, and also someone who is accessible by phone, though they're not required to live in Virginia. And you may appoint more than one person as healthcare agent. However, we caution against this because it creates the opportunity for conflicting decisions, which, if unresolved, could lead to the need for judicial intervention. One of the greatest benefits of an advance directive is avoiding the need for judicial intervention and the associated legal expenses. So it is better to appoint a single agent and ask that that agent consult with others before making a decision. It can also be a good idea to appoint a backup agent in the event the primary agent is unavailable or is no longer willing or able to serve. For example, if the primary agent passes away or loses competency themselves, there would be a backup agent to step in and make decisions on behalf of the patient. There is a provision within the Virginia Healthcare Decisions Act which dictates who gets to make the decision if an agent has not been specifically appointed. Under Virginia statute, the following individuals in this order, on the order of your slide from top to bottom, are authorized to make healthcare decisions for the patient who has been declared incapable of making their own healthcare decisions. If there is more than one person within the specified class of individuals, the majority rules. For example, if the patient's spouse has predeceased the patient and the adult children are the authorized substitute decision makers, and there are 5 children, with 3 wanting to withdraw life-sustaining treatment and 2 deciding not to, well, then the majority rules. Obviously, it's better to have a conversation with the entire family to provide education and explain the patient's proposed course of treatment and outcomes, and to encourage the family to come to a consensus. But this is not always how it works, and the law provides a remedy for those situations where there is a majority of class. We frequently get asked whether proof of decision-maker relationships are necessary. Do you need to document proof of a decision-maker relationship? While Virginia law does not speak directly to this issue, the Medicare COPs, or conditions of participation, for hospitals and nursing homes provide that the facility is expected to accept the assertion and not demand or request supporting documentation unless more than one person claims to be the appropriate representative, or if the facility has reason to believe that the individual is falsely claiming to be the authorized decision maker. Now, there are some instances in which a non-blood relative or spouse can be designated as the authorized decision maker for a patient who is incapable of making their own decisions. Prior to 2010, the law only allowed blood relatives to make decisions for others. But now, a friend can be appointed as a patient substitute healthcare decision maker if, first, there is no one in a higher class available or willing to serve. Second, the friend has exhibited special care and concern for the person. And third, the friend is familiar with the patient's preferences and values. The facility in which the patient resides must also confirm through a patient care consulting committee that the individual is an appropriate decision maker. There are some limitations, however. A qualified friend cannot make decisions involving the withholding or withdrawal of life-prolonging procedures, which means they cannot execute a DD&R on behalf of a patient. A friend also cannot be employed by the healthcare provider that's providing care to the patient, or the healthcare facility where care is being provided. In order for healthcare staff to be designated as a person's substitute decision maker, the individual would need to seek authorization from the court through a guardianship proceeding. Whether appointed as an agent under an advance directive or acting as a substitute decision maker appointed under Virginia statutes because there is no advance directive, there are certain rules that must be followed when making decisions for another person. According to the Virginia Healthcare Decisions Act, agents and substitute decision makers are obligated to first understand and evaluate the risks and benefits of the available treatment decisions. Second, based on that information, must make a decision about treatment that they know the patient would want and not based on their own beliefs and preferences. And third, in the event they are not sure of the decision the patient would make, they are obligated to make decisions in the best interest of the patient. And as a practical side note, if you find yourself in a situation where the agent or substitute decision maker is advocating for treatment that the healthcare team knows was not the wish of the patient, or does not seem to be in the patient's best interest, it's always best to contact risk management or legal counsel so that you can protect yourself from what appears to be the agent's poor decision making. An advance directive can easily be revoked at any time, either by written cancellation, physical destruction, or oral revocation. Oftentimes, the language of a new advance directive will revoke all previously executed advance directives. And this ensures clarity and avoids conflicting directives. Anytime a patient revokes an advance directive, he must have the specific intent to revoke and must also be capable of understanding the nature and consequences of the revocation. One note about copies. While copies of advance directives are valid in Virginia, they can cause confusion if the advance directive is revoked, but all the copies are not destroyed or recollected. An important note is that the Virginia Healthcare Decisions Act does include an immunity provision for providers who are not notified of a revocation. And thus, it's important for the patient to inform their healthcare team if they do revoke an advance directive, and to ensure that they have a copy of the most recent one on file to ensure their current wishes are honored. Another important point is that a patient may make a partial revocation of an advance directive. For example, a patient can change their mind regarding the withdrawal of life-sustaining treatment and execute a subsequent advance directive that only speaks to this issue. Unless the old advance directive is revoked, any non-conflicting provisions of the original advance directive will remain in effect. Also, if a patient protests the authority of a named agent or any person authorized to make healthcare decisions on their behalf, except for a guardian, the individual protested will no longer have authority to make healthcare decisions on the patient's behalf, unless the patient's advance directive explicitly confers continuing authority on the agent over his later protest, which we're going to address in greater depth in a moment. If the patient does revoke the authority of the agent appointed in an advance directive to make decisions on his behalf, regardless of whether the patient is thought to have decisional capacity, future decisions are to be made by individuals in order of priority within the statutory list of decision makers that we discussed earlier. As we've discussed, an advance directive can be used for any and all forms of healthcare treatment, including mental health care. You should be aware, however, that there are a few caveats regarding mental health treatment. A patient's agent can only consent to the patient's admission to a mental health care facility for up to 10 days, and only if the following criteria are all met. First, the patient's advance directive must expressly permit admission to a mental health facility. Second, the admitting facility must certify that the patient has a mental illness, is incapable of making an informed decision, and needs treatment. And third, the admitting facility must be willing to admit the patient. We've spent a lot of time talking about how to create an advance directive and the types of authority that can be granted in an advance directive. However, it's important to remember that an advance directive has no force and effect at all, meaning we should not rely on the decisions of an agent or the decisions expressed in an advance directive unless and until the patient has been formally determined to be incapable of making an informed decision. And now, incapable of making an informed decision is defined in the law as meaning either unable to understand the nature, extent, and probable consequences of a proposed healthcare decision, or unable to make a rational evaluation of the risks and benefits of a proposed healthcare decision as compared with the risks and benefits of alternatives to that decision, or unable to communicate such understanding in any way. Now, poor judgment does not mean that an individual is incapable of making their own decisions. We can't prevent people from making what we think are bad decisions. And also, on that third prong, communication disorders do not qualify. If the individual can communicate in other ways, such as writing, sign language, or some other method, well, we should not rely on a substitute decision maker for that patient. So, how do we go about determining and documenting that a patient is incapable of making an informed decision? Well, the attending physician must certify in the patient's medical record that the patient is, in fact, incapable of making an informed decision, as defined on the previous slide. Also, a second physician or clinical psychologist must concur and also certify this fact in the patient's medical record. There is one exception here where the patient is clearly incapacitated. And now that exception states that the second physician or clinical psychologist certification is not required if the patient is unconscious or experiencing a profound impairment of consciousness due to trauma, stroke, or other acute psychological condition. And if that is in fact the case, that second certification is not required. And on top of all that, this formal determination must be recertified every 180 days. That's typically not an issue in the hospital setting, where patients do not tend to stay for that length of time, but it's a common issue in long-term care settings. And so I want to just stop here and hammer this point for a moment. So our firm is often contacted in risk management issues where the facility has relied on decisions of an agent, and there's no formal certification in the patient's medical record about mental capacity or ability to make informed decisions. Just to reiterate, until a patient is determined to be incapable in accordance with the Virginia Healthcare Decisions Act, they are presumed capable in making their own decisions. It's particularly important to keep this in mind when dealing with the elderly population. Just because a patient is aged and may have a very opinionated family member does not mean that the patient is not of sound mind and able to make their own decisions. Before relying on an advance directive or the decisions of an agent, the law also requires that you provide the patient and their agent with verbal notice that the patient has been determined to be incapable of making their own decision. For patients who have recovered from an unconscious state, or for those patients with varying degrees of lucidity who may be suffering from early signs of dementia, it's important to note that only one physician is required to make a determination that the patient is again capable of making an informed decision. We spoke previously about the situation where a patient objects to their appointed agent making decisions on their behalf, and whether you can continue to rely on the agent despite objections of the patient. Well, the law provides two sets of rules when dealing with patients who have been determined incapable of making their own healthcare decisions. The first set of rules involves the scenario where the patient has executed an advance directive that specifically authorizes treatment over their later protest in the advance directive. In that setting, a healthcare provider must have documented that the patient had capacity at the time the advance directive was made. And remember from early in this presentation, that list of providers who may make that certification was expanded, and that was in 2017 legislation. And I've detailed who may make that determination at the bottom of your page there. Also, as a second point, the decision at issue cannot involve the withdrawal of life-prolonging treatment. And finally, the attending physician must have documented that the treatment is medically appropriate. For the second set of rules involving this scenario, where the patient has not explicitly provided for treatment over protest in the advance directive, in that situation, treatment may be provided over protest provided that the decision does not involve life-prolonging treatment, the decision does not involve admission for mental health treatment, the decision is based on the patient's previously expressed preferences, or if unknown, on the patient's best interest, and the facility's Patient Care Consulting Committee has determined that the treatment is ethically acceptable, or if there is no such committee, then two physicians not involved in the patient's care may document that the treatment is acceptable. We're frequently asked if there's no family or individual available to make decisions on behalf of the patient, can two physicians provide treatment in the patient's best interest? And the answer is no. Some states allow this type of substitute decision making, but Virginia does not. If there's not a statutorily authorized substitute decision maker available and the patient is unable to make their own healthcare decisions, then judicial intervention is required. In Virginia, this two physician standard is limited to the circumstances where an agent is making a decision for the patient over their protest and the physicians are documenting their concurrence with the authorized substitute decision maker's decision. While the Federal Patient Self-Determination Act requires all states to permit the utilization of advance directives, the requirements for advance directives vary from state to state. Most states have reciprocity provisions, but whether or not an advance directive will be honored in another state depends on that state's requirements. Virginia does recognize advance directives from other states and will consider an out-of-state advance directive valid as long as either 1, it meets Virginia requirements, or 2, it meets the requirements of the state in which it was executed. There is also a military advance directive for those in active duty who move around frequently. Federal law requires every state to honor a military advance directive when executed in accordance with federal law. A valid military advance directive must be drafted with the assistance of legal counsel and is limited to addressing only life-prolonging procedures or the designation of a healthcare agent. We recommend that patients provide anyone who may be involved in their healthcare decision-making with information regarding their advance directives, as well as their religious beliefs and treatment preferences. Particularly, the individual appointed as their agent and their physician or treatment team should be provided a copy. We also recommend advising patients that they should consider reviewing advance directives at least on an annual basis, and particularly if there are any major changes in the patient's medical condition or wishes. If discussed with the physician during an annual wellness visit, it is considered preventive, and generally the patient's coinsurance or deductible would be waived. Since 2011, Virginia has maintained an advanced healthcare directive registry where patients may store an electronic copy of their advance directive at no charge. Virginia's Department of Health recently changed the host of the registry, and the link in this slide will take you to that new website of the registry. The old link, which was virginiaregistry.org, is no longer active. The registry provides individuals with information on advance directives and allows individuals to download Virginia's template forms. Once completed, individuals may upload a scanned copy to the registry or fax a copy. At this point, I want to address an issue that comes up frequently, and that's whether healthcare providers are required to provide life-sustaining treatment when it is clear that to the physician and other healthcare staff that treatment is futile. And this is a challenging question that can only be made based on individual facts and circumstances, but I can provide for you what the law says, and that is that the physician does not have to provide treatment that the physician believes is medically or ethically inappropriate. However, if the physician does disagree with the directives outlined by the patient's advance directive or the decisions of the patient's agent, the physician must inform the patient and the designated decision maker of the basis for the disagreement. If conflict remains, the physician must make a reasonable effort to transfer the patient to another physician who is willing to comply with the patient's wishes. Ideally, the conflict will be resolved through a well-documented in-person meeting between the physician, the patient, and the patient's decision maker. However, if you find yourself at an impasse and are unable to reach an agreement, I highly recommend that you contact risk management and legal counsel. Until the patient is transferred, you need to recall that the healthcare team must continue to provide any life-sustaining support, such as nutrition, hydration, management medication, and any such support that's requested by the patient or his substitute decision maker. Thus far, we focused on Virginia law, but I do want to briefly provide for you and address the relevant Medicare conditions of participation and Joint Commission standards. Hospitals and nursing homes are required to document upon admission whether the patient has an advance directive. They must also provide information regarding advance directives when requested and provide staff education and community outreach on advance directives. Today's presentation by HDJN is one way to satisfy this obligation. Now, several times in this presentation, I've mentioned instances where the facility's patient care consulting committee should be consulted, such as when providing treatment over patients of protest or when appointing a close friend in lieu of a blood relative to make decisions for the patient. And now, for some background, a patient care consulting committee can be a subcommittee of an ethics committee or a standalone committee, and it must be composed of at least 5 individuals, including the following: at least 1 physician, at least 1 nurse, at least 1 social services representative, at least 1 individual with clinical ethics experience, and at least 2 independent members. It's not often that a facility needs a patient care consulting committee to make these kinds of decisions, but it's best to be prepared to call this committee when the need arises. If the facility does not have a patient care consulting committee or cannot assimilate at least 4 members, which is a quorum, 2 physicians with the following qualifications may serve as a substitute. In protest determinations, 2 physicians are required that are not involved in the patient's care or determination of the patient's capacity. For appointment of a friend, making those determinations, 2 physicians may be used who are not involved in the patient's care, are not employed by the facility, and are not in the same practice as the attending physician. As I mentioned previously, this does not allow the 2 physicians to make decisions for the patient. It's simply a mechanism for approving treatment authorized by a substitute decision maker over protest, or for appointing a non-blood relative the authority to make decisions on behalf of the patient. As we begin to wrap up, I wanted to make you aware of 2 documents that are similar, but yet have differences from advance directives. The first is the Durable Do Not Resuscitate Order. Unlike an advance directive, a Durable Do Not Resuscitate Order, or DDNR, is required to be on a special Virginia form. It requires completion by a physician, only addresses the withholding of cardiopulmonary resuscitation in the event of cardiac or respiratory arrest, and it does not have reciprocity in other states. DDNRs are governed by their own set of regulations, which, frankly, we could spend an entire presentation on discussing just the DDNR requirements. But what's important for today, in comparison to the advance directive, is that if a patient wishes to have CPR withheld, it is best for the patient to have both an advance directive and a DDNR. There's also a document called the POST, or Physician Orders for Scope of Treatment form. Similar to the DDNR, the POST is an order executed by a physician. But similar to an advance directive, the POST can address treatment above and beyond simply the withholding of CPR. This too is an entire presentation on its own, and I encourage you to seek out more information regarding the POST in Virginia and the benefits of its use in advanced care planning conversation. And finally, as we end today's presentation, I wanted to close with a few key takeaways for you as providers. First, I want to make sure that you have a good process for documenting whether a patient has an advance directive and that it is easily identifiable in the medical record. If a patient states that he or she has an advance directive, but they've not brought it with them, it may be best to ask them to create a new one so it can be immediately scanned into the medical record. Before relying on an advance directive, be sure to read it and make sure it meets the regulatory requirements, which are that it be signed by the patient and 2 witnesses. Oftentimes, a financial power of attorney will be provided and mistaken for a healthcare power of attorney, so it's important to read the document and ensure it addresses healthcare decision-making. An agent appointed under a financial power of attorney does not have healthcare decision-making authority. Then finally, before relying on a document or an agent, Make sure the patient has been formally determined to be incapable of making his or her own decisions, and that this determination has been documented in the patient's medical record. And here are a few resources that you may want to visit to learn more about advance directives in Virginia or nationally, including the Virginia State Bar website, which contains the advance directive form, and that Virginia Advanced Directory Registry website mentioned earlier, which is connectvirginia.org/ADR.
We hope you learned something new about the advanced care planning process and advanced directives in Virginia. Should you have questions, please feel free to contact Mary Malone or Molly Huffman at Hancock Daniel Johnson & Nagel.